leave. And basically, we want to discuss leave management and its practical application on payday. Now, I know that leave is a very common topic that we all encounter when we are processing payroll, that we encounter when we are administering human resources, HR, and it's one of our key functions to look after employees' leave. Now, as we proceed, I want us to then have a look and see. First of all, let's define what leave is. So basically, when you look at leave, the basic definition of leave is time away from normal duty. All right. So this is time away from normal duty. If we say somebody's on leave, we are saying that they are they're having time away from normal duty. Now, before I continue, I also want to welcome, sorry, I didn't welcome. I also want to welcome our Getting Started team that I'm having today, who are joining us live from the base, where I'm actually broadcasting this particular Zoom session. So guys, welcome. Thank you very much for also joining us on this Zoom session that we're having today. I've shown you on how to work on leave on payroll, but we want to also share with our other clients during this Zoom session. Now, like I said, the definition of leave is basically time away from normal duty. Now, when you are away from normal duty, we then say you have taken leave. Now, there are various reasons why an employee can take leave. And in our labor law, we have 4 legislated leave types, which I want to discuss with you. And we are saying these leave types are legislated, meaning that they form the base, the foundation. And every employee that is engaged is supposed to be able to access these 4 leave types. And these 4 leave types include your sick leave, your vacation leave, your special leave, as well as your maternity leave. Now, you'll find that every employee engaged in Zimbabwe who is working and is now being governed by the Labor Act, chapters 28.01, they are allowed to access these leave types. Now, I'm going to be taking you through each of those. And I want to start off first with looking at sick leave. Now, sick leave in our Labor Act is found in Section 14 of the Labor Act. And this particular leave type is granted to an employee that is, number 1, ill or sick, number 2, injured, number 3, undergoes medical treatment. So if an employee is sick, they can apply or access sick leave. If they're injured, they can also apply for sick leave. And if they need to go for a medical treatment, for instance, they are not really sick, maybe they are going in for a medical operation, they can actually come to work and then say at a particular time they want to go for that operation. That is medical treatment. Or they want to go and visit the doctor. That is also medical treatment. They can access sick leave. However, subsection 1 of the Labor Act goes on to say that this type of leave can only be accessed if the employee has not failed to take reasonable precautions. If the employee fails to take reasonable precautions and then they get injured, they are not allowed to take sick leave. That means as payroll administrators, we simply do not take an instruction from an employee at face value. We need to look at the merits of the case. I'll give you a very good example. If an employee comes to work and they are working in an area where they're supposed to wear protective clothing, for instance, a helmet, and they do not wear that helmet in that particular area and they get injured in that particular area, they cannot access sick leave. Why? Because they failed to take reasonable precautions. Now, a lot of us skip this particular part. But really, the law is giving personal responsibility to also making sure that they protect themselves from injuries, because they have a responsibility to do their work when they come to work. So it's very, very important that we also look at this. Now, for an employee to be able to access this sick leave, they must also hand in a medical certificate, which we normally call a doctor's note. And this doctor's note can be issued by 3 medical practitioners, which we can look at. Number 1, there is the SRN, which is the state registered nurse. These are the ones that we find in polyclinics, the ones we find in government hospitals and mission hospitals. and they are only allowed to give a maximum of three sick leave days. So if an employee goes to a clinic and they come with that brown card, or they bring a book, these days you can actually have a small book for your medical history, which is stamped by the clinic, and they come and they're saying they've been given 24 days sick leave. The first thing we should ask is, did they see a visiting doctor at the clinic? And if they say, no, I was just attended to by a nurse, it means probably that sick note is fake, because there is no nurse that is allowed to give more than 3 sick leave days. So please take note with the contents that are brought by your employees, the medical certificates that they bring. The second is your medical practitioner is your doctor. And here you can also look at your specialists. So when you look at your doctor, you're saying those are GPs, general practitioners, those guys who have medical chambers, maybe at the shops, or if you go to a referral hospital, or if you go to a clinic and there's a visiting doctor, those doctors are allowed to grant a sick leave. You can also get specialists like your gynecologists, your dentists, all those guys who are in the medical profession also grant sick leave. And what are the amounts that they can grant? They can grant 90 days on full pay, and they can grant a further 90 days on half pay, meaning that an employee can access, with the help of this doctor, can access 180 days sick leave per year. Now, the third medical practitioner that can also sign a sick note is your traditional healers. Now, these ones include your faith healers. They include your traditional healers, your ngangas, your witch doctors, all those people. They are also allowed. Your herbalists as well. Those that have herbal clinics, they are also medical practitioners, and they can grant up to 90 days full pay and 90 days on half pay as well. But there's only one condition for these traditional healers. They must be registered with Zinata. So if an employee brings a medical certificate, which is signed by one of these faith healers, what you now need to check is their registration with Zinata, and they should give you their registration number, which they must quote on their medical certificate so that you can do a follow-up. All right. So these medical practitioners can sign the doctor's note and they can support. But let me be very quick and clear here. I don't mean to be a devil's advocate, but I think it's important that we also realize that when an employee applies for leave, that's why it's called an application. They cannot really demand leave. They can apply for leave, meaning that the employer has enough authority to grant or to deny that employee going on leave. It's within the employer's right. Why? Because it's the employer who's giving work. It's the employer who is offered employment. So they have their right to say, I think this is a fake note, so I'm not allowing you to go on sick leave. Yes, it might sound harsh, it might sound bad, but at the end of the day, some employees are also taking advantage of this particular offer that has been given on sick leave. So it is always good to set a precedence. If an employee brings a doctor's note, go and investigate. Call the doctor. Ask if the employee visited them. They don't have to disclose, because there's that right within the employer not to disclose, but you can ask just to get confirmation. And you can tell them and ask them to say, are you willing for us to get a second or a third opinion from our own doctors, since you're asking our employee to go on sick leave? And usually, if it is something that is fake, you find that the doctor will try and negotiate with you, because such kind of practice can lead to them having their licenses being revoked. So it's very, very important that you set a precedent so that when employees then bring their sick notes, they don't bring fake sick notes. All right. I just thought maybe it's important for us to discuss that as well. Let's look at the second one, vacation leave. Vacation leave is found on Section 14A of the Labor Act. And basically, an employee is granted for personal business. They don't need to disclose. Are there employers who say, you want to take vacation leave? Tell me why. It's within the employee's right to say, I'm not going to tell you why I am taking this vacation leave. It's within their right. Why? Because it is their personal business. And this is the only leave type where the employee does not need to disclose because it's within their right. Now, when you look at the accrual for this one is 1/12 of the qualifying service. Now, 1/12 of qualifying service, basically, this is 1/12 of the first year of employment. If you go and check in section 14, subsection 1 and subsection 2 of the Labor Act, it actually says that your qualifying service is the first year of employment. So if the employee can access 1/12 of the qualifying service, of the qualifying service being 1 year, it means it's 1/12 of 12 months. And basically that is 1 month. So the Labor Act grants an employee 1 month out of 12 months as vacation leave for them to be able to go and rest. And now that one month can be interpreted in two ways. It can either be in calendar days or it can be in working days. If it is 30 calendar days, it means you're including your Saturdays and Sundays as well as your public holidays. If it is working days, you are simply looking at the days the employee is actually expected to report for work. So you can use either of the two. And if the employee, for instance, is accruing at 30 calendar days, that means the employee is accruing 2.5 days per month, which will give us 30. Or they are accruing at 22 days, which gives us 1.833 per month, which gives us 22 days. So it's up to you as an employer, which one you find is a best fit for your organization. All right. Both of them are permissible. Now, an employee is allowed to come up with, an employer is allowed to come up with plans, what we call leave plans for your employees. I'll give you some examples. There are companies that have what we call an annual shutdown. Now, when you have an annual shutdown, basically you're saying you close operations in December during Christmas period. You can say we will close from the 15th of December up to the 15th of January. That is an annual shutdown. Now, what that means is every employee can only access their leave days when they get to December. During the year, employees are not allowed to go on leave. They have to wait for the annual shutdown. That's a leave plan. And it's permissible at law for an employer to do so, especially when they see that the model of business that they do, the nature of what they're doing, that's the best format. And some even take that advantage to have their machinery being serviced and also getting things being done, the good housekeeping issues during the time when there's a close down. All right. Some will also have leave plans where they ask employees at the beginning of the year to indicate which month they want to go for leave. So at the beginning of the year, everybody then indicates when they want to go for leave so that everybody is in the know as to when so-and-so is going to be away. And you can actually then plan your department, plan your work around those leave plans. Now, those are important, and you can also have those being implemented. The reason why we have these leave plans is to also manage the leave liability. Because when employees accrue leave days, it's a liability to the organization. Because if the employee then decides to resign or leave, the employer must pay as part of terminal benefits those leave days as money. So it's important for an employer to keep costs down. And by keeping your leave liability down, it also helps you in managing that liability on your accounts. All right, so that's on vacation leave. Vacation leave is on section 14. Section 14B is your special leave. Now, this is special leave that is granted for special circumstances, all right? Now, special circumstances, these are outlined in the law. For instance, if you're in contact with somebody with an infectious disease, or you are called to be a witness in any court in Zimbabwe, whether it is the community court, whether it is the Supreme Court, any court in Zimbabwe, where you are called out to be a witness and not a primary suspect, a witness. If you're called out to be a primary suspect, it is a different issue altogether. But if you're going in as a witness, you can also apply for special leave. You can also apply if you're going for trade union business, or if you're detained by the police, or if at the death of an immediate family member. And by immediate family, we are looking at your spouse, children, and parents only. It doesn't say your mother-in-law. It doesn't say your father-in-law. It doesn't say your brother. It doesn't say your uncle. So you cannot access for any of those special leave. If you want to go for your father-in-law's funeral, you have to apply for vacation leave. It is now personal business. It's not special because they are your father, but at law. Uncles, aunts, they are looked at as extended family and not immediate family. So you find for those, you then have to apply for vacation leave. However, if it is an immediate family member, you can apply for special leave. And then also on compassionate grounds, basically we are saying at the employer's discretion, where you can come in with a very unique case and you can ask your employer for time off. For instance, an example with the ladies, maybe at home, the maid didn't come back from the weekend, so there's no one to mind the children. So you have to ask for time to mind for the children. You can then ask for special leave. And it's up to the employer to look at the case and then say, well, that's fine. You can take compassionate grounds as well. All right. So remember, special leave, it's only 12 days per year that you can access. And they do not accrue, meaning that if you don't use them in the current year, they will not accrue in the following year. They fall away at the end of the anniversary of your year of employment. All right, that's on special leave. And then the last one, which is maternity leave, before we move on to payroll, which is your maternity leave. This is now on section 18. Now, maternity leave, basically, it is granted to a female employee to nurse a newly born baby. She is granted 98 days, which is 14 weeks. This is coming from the International Labour Organization, which is an arm of UN, of which Zimbabwe is a member state. And we are then, by statute, directed to grant 14 weeks, which is 98 days. If you compare with our national constitution, Section 65, it simply says at least 3 months. So our constitution says 90 days, but because we're a member of UN, we can then also grant our employees 14 weeks of maternity leave. Now, for them to be able to do so, in the past, before 2023, they were supposed to serve at least 1 year before they access maternity leave. However, with amendment number 11 of 2023, that requirement to serve at least 1 year before accessing maternity leave was abolished. What that means, therefore, a female employee can access maternity leave at any time during her employment. Even when she's on probation, she can actually go to maternity leave. And she doesn't need to negotiate with the employer. You know, you used to negotiate in the past to say, okay, at least pay me 1 month or something like that. Nowadays, you can go on maternity leave even on the second day of employment. You can go on maternity leave. And if you do not confirm that employee after probation, we can even cite that there is what? There is discrimination based on pregnancy. So it's quite difficult. However, it's a debate that is coming. Some people say it's good because a female employee can go at any time, but some are also saying that it also has repercussions, whereby you'll find that now a pregnant employee will not have a good chance in getting a job after an interview, because people will then say, we need to pay 90 days while she's not even working for us. And you'll find that a lot of companies now do what we call medicals. And one of the things that they test for, without even telling the employee, is they test for pregnancy. And they won't tell you that you're testing pregnancy. They'll say, we want to look at hepatitis B. And so they need a blood culture. And that blood can simply tell whether the employee is pregnant or not. So the incumbent may not even get the job. So you find discrimination can actually happen at recruitment because of this new amendment that came in 2023. However, it's your take. You can take it. This is the thing. This is the way things are. So with this one, the parameters for maternity leave are that a female employee cannot proceed on maternity leave between 0 and 7.5 months of pregnancy. So she cannot ask for maternity leave before she is 7.5 months pregnant or more. If she falls sick due to the pregnancy, she can ask or she can apply for sick leave, supported by a doctor's note. And so she can apply for sick leave during that period. However, if she is 7.5 months pregnant or more, she can begin to apply for maternity leave, especially if there are complications or the children are born premature and then she needs to start taking care of the kids. She can actually apply for maternity leave. The parameter also says that she must proceed on maternity leave by the 21st day prior to the expected date of delivery. What that means is 3 weeks before the date of delivery, an employer is allowed to turn an employee away and say, can you now go and wait? Because remember, the expected date of delivery, which is your EDD, gives you a provision of plus or minus 2 weeks to that date. So you find that 3 weeks before that date, we are now within the range in which doctors say at any time the baby may arrive. However, some employers are also lenient with employees and allow them to go on maternity leave on the day the baby arrives. I've had people who have even started giving birth whilst they're at work. Or they come to work and the following day we are told, now there's a and yet they were in a board meeting the previous day. All right. So it's up to the employer's discretion. The law simply allows you to turn them away, of which I think for the health of the baby, it's good that a female employee goes to rest and wait, because some jobs are very pressurizing and they can increase an employee's blood pressure, which can be very damaging to a fetus. So it's important that as an employer, you can also take a position. You can put this in your HR policies to say, if you are pregnant, we will allow you to come to work up until 10 days or 5 days prior to expected date of delivery, of which we don't expect you to report for duty. I think it's allowed for you. You're allowed to do so. All right. And then whilst they're on maternity leave, all their benefits are accessible. There are people who have always come to me and said, Nick, if somebody goes on maternity leave, why should we pay them transport allowance? If it is part of their contractual obligation for them to get transport allowance, even if they're not coming to work, give them their transport allowance. Why? Because you have obligated yourself as a company to pay transport allowance. So you give them. You don't also take away their company car. It's the same. If an employee goes on maternity leave, you don't say to them, well, you're not doing company business, so we are taking your company car. Your company car was not given to you on the basis of doing company business only, but it was given to you as part of your benefit, which is a contractual obligation. So every employee must then be able, if they have their company vehicle, they take it home with them and they use it as though they are at work. Things such as pensions, things such as all other benefits that are accruable to the employee, they are supposed to get them. In other words, there is no break in service because an employee is exercising their right to be on maternity leave. So women, through this act, are protected. Even promotions, they have in the past used to have instances where a female employee goes on maternity leave. When she comes back, her subordinate is now her boss. They've been promoted. That is not allowed. If she's due for promotion, even while she's on maternity leave, she must get her promotion. She is allowed, and it is her right for her to be able to get that as well. All right. And then after that, she is also allowed 1 hour nursing for her baby. This is after she returns to work. She is allowed to take 1 hour per day to nurse a newly born baby for the next 6 months. This is a provision for her to be able to look after the baby. And depending with the organization, an employer may grant her either to come late to work. That means if she's supposed to start at 8, she can come in and start at 9, because that 1 hour she's using it to breastfeed and so forth. Or if she brings the baby to work, or she's close, the baby's in close vicinity, if she takes a tea break at 10 to 10:30, she can take another extra 30 minutes to then take it from 10 to 11 for her to take her breastfeeding hour. And then the other 30 minutes, she can take them in the afternoon. Another common practice is she can actually combine her lunch hour and her and her nursing hour, and then she leaves work early. So she works through lunch, and then at 2:30 she then goes, because at 2 hours from 2:30 to 4:30 will then be used, so she can actually leave early at 2:30. However, these kind of configurations are not a right to the employee. They're a privilege. The employee has a right to the hour, but when she takes the hour is at the employer's discretion, so that it does not disturb production at work. So you can't force others to work during lunch just because you want to go at 2:30. No, you have to then work within the confines of the production flow within the organization. So these are the 4 legislative letters I wanted to discuss with you. Now let's go into the payroll. So I want to look at how you implement this on payroll, and then I'll open up the floor for any questions. So allow me just to share my payroll. All right, give me a moment. All right. So let's come on. I'm now bringing on the payroll so that we can also have a look at the payroll. Now I'm sharing my payroll. So the first thing with leave, on payday, you're also able to, let me just do this for the benefit of my team here. Just going to do that so that they can also see. Right. When you're now looking at leave, the management of leave on payday, firstly, you can set up the different types of leave on payroll that you're going to access. Where do you set up these different types of leave? If you go on your main menu, you can actually go on to your codes, and under your codes, you'll find you also have where it says leave types. And so if you select your leave types, this is the screen that allows you to then set up your different types of leave. So if I scroll here, we can have a look at the different types of leave that we have. Now, the first one that has come on mine, you can actually go and check on yours, and you can actually see the different types of leave. I have A being the first leave type, and it is cash in lieu of leave. Now, as we all know, cash in lieu of leave is the conversion of my annual leave days to their monetary form. So on payroll, you are also able to convert these leave days into their monetary form, and the code that will then appear on your payslip, you can see it there where it says earnings or deduction code, which is now cash in lieu of leave code 420. So you find that this particular leave type also affects annual leave. In other words, if an employee takes cash in lieu of leave, it's going to reduce their leave balance, their annual leave. If you go and tick it on sick leave as an example, if somebody then takes cash in lieu of leave, it would increase their sick leave days. But that is incorrect, because cash in lieu of leave is not part of sick leave. Cash in lieu of leave is part of vacation, where one is converting their vacation leave days. That's why you find it's going to affect your annual leave days. If I go and look at the next leave type, which is sick leave, which is on B. Now with sick leave, you're going to find that it has been indicated to affect sick leave. Now, sick leave is no monetary form, so you find there is no code or no earnings and deduction code. However, if somebody takes sick leave, it's going to increase their leave, sick leave record until they get to the maximum 90 days. So each time somebody is taking sick leave, it's adding to the days that they've taken, adding until you get to 90 days. If I go to the next leave type, which is my annual leave, this is now for somebody who's actually going away to rest. They are not converting their leave days to money, but they are simply going to rest. you can actually have those. And you can see it's going to affect our annual leave days, meaning that if somebody takes annual leave, it will reduce their leave accrued or their leave balance. So you find that this is where you then set up the different types of leave. If you want to set up your own leave type, you may have an internal arrangement that you may have. You can actually come and select a particular letter which you want. As you can see, I've got A, B, C, D, E, F, G, and X. So I can actually use any other letter that is not here. For example, if I want to create another one, let's say I want to use K as an example. I can go and put K, and then I can give it a description. Let's say I'm going to simply call this executive holiday. I wish I could have an executive holiday, actually. And then my executive holiday, if I take this, it's a benefit to executives. Therefore, it's not going to affect their annual leave. It's not sick leave, neither is it special leave. So I'll go and select none. And then I can click on apply. That means now I have created a new leave type, which is not affecting my annual leave or my sick or my special leave. But I can use it to record each time an executive goes on holiday. And I can actually go into the payroll and then into my leave records, and I'll be able to do so. If you remember very well, for us to record our leave, I think I've shown you this one now. To record our leave, you can now come to maintenance. And then you can go to your leave records. And under leave records, this is where you can now record the different types of leave. If I select, for instance, the first employee, if you remember very well, at the bottom of my screen, this is where you find the historical records, the processed records. And if I want an employee then to go on leave, I can record their leave. And as you can see, I can then come and select the leave type that I have. And you can even see the new leave type that we have created, which is now our executive holiday. I can put it from when to when, and your employee will be able to go on leave. So this is where you then record your leave. You record all types of leave here. From the cash in lieu of leave, you also record it here. Your sick leave, you record it here. Your annual leave, you also record it here. Any type of leave that employees take, you record it here. The good thing about payday is that if you record your cash in lieu of leave here, the system will automatically convert those days to their monetary form. For instance, if I take, and let's say I'm going to be taking, we're running now my payroll, I think it is in April. So I'm going to be running an April payroll. So if I select an April payroll, let's say I want to convert my days, say 21. Let me just set that again. And let's say I want to sell 10 days. If I put there 10, and if I click on why I want to sell those days, and let's say I want to pay school fees as an example, and then click on apply. Once I do this action, the system will also automatically convert those days. It will automatically convert those days and then put them on the employees' earnings and deductions. And you can actually see the employees' cash in lieu of leave being converted there. So if I select my employee, you can actually see the leave that has been put through the cash in lieu of leave, and you can see the 10 days that have been converted. If you are on a dual currency, it will give you the value for the ZIG basic. It will also give you the value for the USD basic. That's why you have your ZIG and your USD, and it will then post it onto your earnings and deductions. So when you're doing your cash in lieu of leave, you simply do it when you are actually in your leave records, and the system will do the rest for you. Another common question that I normally get in leave management on payroll is that, Nick, how do I reimburse somebody's leave? For instance, somebody has, I posted leave for the wrong person, deducted days for the wrong person, and they come after they've seen their pay slip that their leave balance is reduced. We've already closed payroll. We are in the next month. How can I then give or reimburse that employee their leave? And the best way to do that, again, you do it in your leave records. You go and you select annual leave. because that's the one that is the monetary form. You can put in the pay date again, or you can put in the days of the cancelled leave. It also works. But what is very important, under the column headed days there, this is where you would then put in the days as a negative. Please remember that. You then put the days as a negative. So let's say we want to reimburse the employee 5 days. You'll then go and put a -5. So I can come onto my system and put -5. And then I can put in a comment to say leave adjustment. And what the system will then do, it will use the mathematical principle that a negative and a negative will give us a positive. So instead of deducting 5 days from the employee, it is going to add 5 days to the employee's leave due and give that employee those days as well. Okay, so please remember, this is how you would then reimburse. If you find that you've got leave balances that are not correct and you want to add more days to employees, just put in the days as a negative on your annual leave days. Now, the last thing I want to show you under our leave are the reports that you can get from leave. What reports can you print under the payroll, under your reports menu? So if you go to your reports menu and you select my reports, and if you come to your current schedules, we've got a variety of reports that you can actually print from the payroll. For instance, the one that we recommend the most is the leave report. Now, with your leave report, basically this shows you the leave movement for your employees. So if you select the leave report, you're going to see that the leave report will show you the employee code. It will give you the name of the employee. It will give you the opening balance of that employee. It will give you the leave accrual, which is the entitlement, the days taken by the employee, the balance carried forward, the entitlement per year, and the value of that particular leave. So you see everything that has to do with the employee's annual leave. You can also get it from this particular report. A second report that you can also get is the leave evaluation report. Now, your leave evaluation report is also very, very important because it can give you the converted values for your employees. You can actually see everything there for the employee. So the leave evaluation report, it will give you a list of the employees, the leave that is due, the value in ZIG, and the value in Forex. You can also get the leave provision. This is your leave provision that you can actually get from the payroll. Now, the last report that I'll show you, which you can actually look at, and it's not the only one, and these are not the only 3 that I've shown you. There are quite a number of other reports, is the leave statement. Now, the leave statement, basically we designed this one for that problematic employee who thinks that you are doing something dubious with their leave. You can actually print a leave statement which can show what has transpired on an employee's account. And this one is also, sorry, let me just put 0004 there. It can actually then, sorry, take another one. I want the leave statement, not the loan statement, the leave statement, sorry. Right, so as your leave statement, you can say from when do you want to start that statement? Let's say we want from the 1st of January 2025. So we're going to be going for the whole year of 2025. And which leave tab do you want to look at? It's always the one that is always in scrutiny is the annual leave. So you can select annual leave, but you can also select all the other leave types as well. And then from there, you can select under your category. Let's say I want employee code. And then I can select the employee. I'm just going to say from 0004 to 0004 again. I just want one employee. And then I can click on preview so that we can have a look and see at the report. So as you can see, what this leave statement then does, it gives us the employee code, the name of the employee, the leave that is due, the maximum that they can take, any special leave that they've taken, any sick leave days that they've taken, and then the balance brought forward as at the 1st of January 2025. How many days did this employee have? You can see the balance there, and all the transactions that have taken place, including the accruals that have taken place for that particular employee. If they took any annual leave, you can also see when they took and how it reduced the balances, so that you can actually then reconcile right up to the point where we are today with their particular leave. So an employee can trace on their own and they can see what has transpired on their leave. So these are some of the leave reports that we've put in on payroll that can also help you as you are managing your leave. Right, I think for my presentation for today, I am going to stop here for now. We normally do these, especially when we have our getting started courses, our refresher courses. You can also get them from there. Otherwise, at this particular juncture, let me open up the floor. If there are any questions that you guys might have, you can go ahead and unmute yourself and you can ask your question if you have any questions at all.
Hi, Nikki.
Yes, Mr. Mawods, how are you, Newton?
I'm okay. Right. I just want to maybe to touch on the last part of the special leave, which talks of on any justifiable compassionate ground. What are some of the examples which we can cite as the compassionate ground?
Okay, thanks, Mr. Mawoza. Compassionate grounds, basically, for us to then say 1, 2, 3, 4 are the compassionate grounds, it's quite, we cannot exhaust. Why? Because there are very different circumstances that employees can bring. All you can do here with this one, we are saying the act is giving you, the employer, the discretion. So an employee can bring any case from, like the example I gave you, a maid that doesn't come back to work and there's no one to mind the children. Or a child has been injured at school. And so the school calls you as the parent to come and collect that child. Or you are not sick, and it's just a special circumstance. And now the employer can look at how genuine that request to be away from duty is. And it's up to the employer to then give us that discretion. So it can be anything, Mr. Mawoza. Every case that is presented, you look at its merit, and then you can now give that particular case, whether you'll agree or you'll disagree to give them that one. One which I can also mention, which the law doesn't really mention, but you can also include it as part of special leave, is if employees participate in a national event, where, for instance, if they are called out to enumerate in a census exercise, or they are called out to be part of the voter registration process or the voting process in an election. Those national events, if your employees have been called out to do so, then they can also apply for special leave. I didn't mention this one, but that's another one. Or maybe they are part of a national delegation representing Zimbabwe. Maybe they are part of a national team going to a different country and they are representing Zimbabwe on a national capacity. They can also apply for special leave. I just wanted to mention those as well. Carol has also brought in, how frequent can an employee apply for maternity leave? Thanks, Carol. Thanks for bringing that up. In the past, before 2023, the amendment number 11 of 2023, a female employee was granted a maximum of 3 maternity leaves with one employer. After that, the 4th maternity leave becomes unpaid. But with the new amendment that has come in of 2023, amendment number 11, that requirement to have a maximum of 3 maternity leaves with one employer has now been abolished. meaning that she can have as many kids and go on maternity leave as many times as she so wishes to do so. It's just up to her health and her husband what they agree to do, or partner, sorry, what they agree to do. So there is no cap anymore. She can go on maternity leave as many times as she feels she wants to do so. Okay. Also, there's the question, maybe if I can also mention on this one, the requirement to also observe the 2 years prior to the last maternity leave. Again, with that one, an employee can go on maternity leave on any particular time. That observation is really not there anymore. That means she can go every single year on maternity leave. However, usually it's not recommended because her body needs to also recover from the previous maternity leave. So it is always good to observe the 2-year spacing that is given. All right. I hope I've answered you, Carol. All right.
Hi, Nick.
Go on. Hi.
How are you?
I'm very well, thank you, sir. How are you?
Fine, thanks. Just a comment on special leave.
Yes.
On compassionate grounds.
Yes.
The list, like you said, it's quite endless.
Yes.
And anything can fit there.
True.
So what I usually do is to consider giving someone compassionate leave when they've exhausted their vacation leave days.
Okay.
Yeah, so when you don't have vacation leave days, you can then say, okay, utilize the special leave on compassionate grounds. But if you've got your vacation leave days, take your leave days, your vacation, and go.
Okay. All right. Okay. That's a good strategy where you are saying before one can access compassionate leave, they must first of all exhaust their annual leave. In other words, they cannot take compassionate whilst they still have a leave balance within your organization. That is permissible. If you have agreed with your employees to go that route, again, that is permissible. Some don't do it, but if you are doing it that way, I believe it also helps manage your leave balances, your leave liability, because people then first have to exhaust their leave days on any personal business that they might have. Thank you very much, Marvelous, for also sharing that with us.
Okay, thank you. Welcome.
All right. Any other comments or any other questions that you guys might have?
Hi, sir Nick.
Yes, Mr. Piri, how are you, sir?
I'm fine, sir Nick. Don't we have a paternity leave in Zim?
Thank you for bringing that up, Mr. Piri. I think Rejoice also brought that up in the Getting Started course. I'm not sure. But in Zimbabwe currently there is no paternity leave. We only have maternity leave. In South Africa, they actually have paternity, where the father takes the first 2 weeks, which is 14 days. They can actually take that as well. And that is allowed. But in Zimbabwe, let's lobby for it. Rume, I think we have all these action groups for the men. We can also lobby for it so that we can also get it. Now, it's a very genuine concern because when a child is born, they do not understand time and so forth. So you find that even the father can also be disturbed their sleep when they're supposed to rest. And they wake up because the baby is crying during the night. And that can also affect their productivity at work. And so you find that it's also good for the first 14 days or so for a father to also take time away. But we know our Zimbabwean fathers, let's be honest, we may not use that time with the baby, but we'll be actually hustling and bustling and going for boozers and things like that. I'm just kidding. But yes, in Zimbabwe, we don't have paternity leave, just to answer you, Mr. Perry. Right. There's another question that has come. Is there a number of days limit of compassionate days for the death of an immediate family member? Yes, there is a limit on compassionate days. Our limit is 12 days per annum. That means if they exhaust those 12 days, even if an immediate family member then dies after they've exhausted those days, they now begin to apply for vacation leave. So you only get 12 days. And it's not 12 days per funeral, it's 12 days per year. So if they use up those days in one funeral, it means all the other funerals coming through, they cannot access them. They cannot access special leave. They will have to apply for vacation leave. All right. Now, for each event, there is no limit really for each event because every event takes its own toll. But like I said, for every event, if they use up their 12 days, then they now need to use their vacation leave days. So after using up their 12 days, you now encroach into their leave days. And you find normally they don't want to be using those for funerals and things like that. So you find the rate at which they apply for vacation leave for funerals then diminishes. All right. Otherwise, thanks, Carol, for those questions. Are there any other questions that you guys might have?
Yes, Nick. Hi, how are you?
Hi, Tapio. How are you doing?
I'm all right. I just wanted to confirm, I'm not sure if you talked about this. I've noticed when it comes to entering sick leave days, right? So let's say, for example, an employee applied for 10 days in January and then they apply again in June. I've noticed it's not automatic for the balance. I have to go through the records from beginning of the year and then I have to subtract separately and say 90 subtract 10. Is it the way we're supposed to do it, or there's another way we're supposed to do it?
Okay. Right. The way you are doing it, you're actually going it the inverse way. With vacation leave, you increase the days by incrementing their days, isn't it? An employee accrues 2.5 every month. With sick leave, the employee also increments as per the number of days that they have taken. Okay. Now, if they have taken 10 days, we are not saying we should subtract 10 days from 90. We accrue 10 days towards 90, with being the maximum. So the maximum is what we just keep as a record. And once an employee then reaches that maximum, we then go and change their basic salary. So there is no need for you to then say 90 minus 10, then 80. There is no need for you to be doing that. You just leave it as is. Once you get to your 90 days maximum, then we can change their basic salary to half pay. And that's what you just need to do. Okay.
All right. Thank you very much, Nick.
Yeah, most welcome, Tapua. Thanks for bringing that up. All right. And says, I think Carol again comes in and says, I know some countries that sick people are supposed to be either at home, at the doctor's, or in hospital, not out and about socializing, shopping, etc. Very true. What you're simply saying there, Carol, is a lot of people also take advantage of sick leave. I know of people who can even be on this platform today who can be guilty of taking sick leave when they're actually not sick and they just want to go and do one or two private things without necessarily reducing their leave days. It is not a good practice, and you can actually set a precedence. The precedence that you can set there is by simply then saying, if somebody takes, let's say, 2 weeks sick leave, visit them. If they say they're in the hospital, visit the hospital. All right. And go and see. Once you do it for one employee, they will tell the rest. So if they're using it for their shenanigans, they will then not be able to do that as well.
Mr. Nick, I've got a question.
Hi, Amanda. How are you?
I'm good, and you?
I'm well. How's Victoria Falls?
Victoria Falls, it's okay. Today is like it wants to rain. Maybe it will rain later.
Okay, let's hope it does. Okay, you can go ahead with your question.
Okay, I wanted to ask, we've got, for instance, we've got one of the employee who got injured at work, is it on October, if not mistaken, October, November, somewhere there. So again, with these 90 days, does it apply for those who got injured at work?
Yes, it does. Because when you get injured at work, it's one of the parameters where you can access sick leave. If you go and read section 14, subsection 1 and subsection 2, you can find that an employee who gets injured can also access sick leave. The only parameter where they cannot access sick leave is if the injury was due to their own negligence. where they did not take reasonable precautions to ensure that they don't get injured. In other words, they don't wear their PPE, their protective clothing. In that instance, then it falls on them that they become injured. And it's in those kind of instances where you can then say, we are not going to grant sick leave. You can go on unpaid leave, but we are not granting you sick leave because you were negligent. I hope I've answered.
Okay, then my question again is for the 90 days for the half pay. So if that person was injured at work, so should he be affected by half pay whatsoever?
Yes, because it's a provision at law. So for instance, if they get injured and then they go and they go on sick leave for the first 90 days, they can, and they are not, they don't recover. You can actually extend other days, but law says it's on half pay. After and in some sense, you actually have to have a medical board to be able to do that termination. But you are then allowed to terminate the contract of employment. However, normally the good practice is if an employee is injured at work or is injured outside work, or they apply for long tracts of sick leave, it's always good to get a second and third opinion from your own doctors. In this case that you've given to us, we all know that they got injured at work, so you don't need a second opinion. But if it is something that happened outside the perimeters of the workplace, maybe they were at home, whatever happened, then you may need to get a second or third opinion to ensure that the sick leave application is genuine. I hope I've answered you there.
Yeah, you've answered me because I had that query, like, of course, yes, the 90 days is elapsed and then it's supposed to be on half pay. But again, is it fair for us to be paying him half salary instead of food because this thing happened at work?
Yeah, right. I can quote a very learned man called Love Momaduku, who says law is not there to be fair or unfair. Law is simply law. So even if you had to say, well, the employee is sick and you're supposed to pay them half pay, that's the law. Whether it's fair or not, that's a different issue. But as a payroll administrator, you must then reduce it to half pay. However, the law, if you look at subsection 5 of section 14, goes on to say that an employer can grant an employee their leave days, their annual leave days, as part of sick leave, so that you don't reduce their pay to half salary. Okay, you also have that provision. So you can tell the employee that we are supposed to put you on half salary now, but because you have another 30 days on which is your leave, your vacation leave, we're going to pay you another full salary, but reduce your vacation leave days. After that, we then start your provision is there in section 14. I think it should be subsection 5.
Okay. Okay, on that. Thank you, Mr. Nick. I've understood.
All right, you're most welcome, my dear. All right, I've got Mercy Capito here who has also come on. He says, hi, Nick, if a person is involved in an accident outside work, should the company provide them with e.g. arm sling or wrist support years after the injury? Now you want me to be the devil's advocate, Capito. Right. Let's look at this one. If an employee gets injured, the law doesn't say injury at work. The law says simply injured. So yes, if they get injured, then they can apply for sick leave, especially if it is then confirmed by the doctor. So that one is okay. Whether it's within the premise or outside the premise, we've dealt with that. Now, in terms of support and things that the employer can also do, the law is silent on the kind of support that the employer can give. For instance, it's up to the employer's volition to say, well, we will help you with ergomatics, things that will support your back, things that will support you, maybe a clutch or a wheelchair. It's up to the employer's discretion. However, the employer is not obliged to then support that way. Why? Because we have medical aid. That's why medical aid should come in. We also have sick funds. That's why sick funds should also come in. And the employee salary should also cover some of those medical expenses. If you remember very well, I'll give you a good example. If medical aid does not pay part of your medical bill where you have a shortfall, the employee has the onus to pay that bill. So in this regard as well, if an employee needs to get other equipment to help them recover, even years after the injury, the onus is really not on the employer, but it is on the employee. They are the ones who are supposed to pay